I'm Ben Meiselas from the MeidasTouch Network, and this is a breaking news alert. Donald Trump's lawyer, who conspired in connection with the January 6th insurrection and the overall plot to overthrow the results of the 2020 election, has officially lost his appeal before the Ninth Circuit Court of Appeals to try to stop the January 6th committee from reviewing the 8 emails which was adjudicated by the lower court, the federal district court from the Central District of California, as being subject to the crime fraud exception, namely a finding made by federal judge David Carter in the Central District of California that Donald Trump and John Eastman, one, engaged in criminal conduct in connection with the insurrection and attempts to conspire and obstruct the peaceful transition of power and overthrow the results of a free and fair election, and that the 8 emails at issue were in furtherance of that crime. Now, that Judge Carter order finding the crime fraud exception applied was made back on October 19th, and John Eastman was ordered to turn over those emails to the January 6th committee by October 28th. John Eastman waited until October 27th, one day before he was required and ordered to turn over those records, and filed before the district court, before Judge Carter, a motion for reconsideration and a motion to temporarily stay the January 6th committee from getting their hands on these records that he was ordered to turn over. Judge Carter rejected that requested relief by John Eastman in the morning hours of the 28th. John Eastman then rushed and ran to the Ninth Circuit Court of Appeals and begged them for an emergency stay to stop turning over these records and to file an appeal to try to overturn the district court's ruling. But the Ninth Circuit is not just catering to John Eastman whims because he waited until the last second. So the Ninth Circuit didn't rule. John Eastman turned over the records to the January 6th committee, and the January 6th committee reviewed and read these records on October 28th. The general counsel from Congress sent an email saying that John Eastman was ordered to turn over these records, and pursuant to the order, and no order to the contrary, the January 6th committee reviewed the records. John Eastman then ran and whined to the Ninth Circuit Court of Appeals that the January 6th committee reviewed records, which he said they shouldn't have reviewed because he had a current appeal, or said that he was going to appeal the order. He hadn't heard back from the Ninth Circuit as of that point, and then filed his appeal. Thereafter, the January 6th committee filed their opposition to John Eastman's emergency application before the Court of Appeals. And because John Eastman sent those 8 emails using a public Dropbox links and not sending it through any encrypted software or coming up with a way that lawyers would normally try to send kind of confidential records, or to send things in an encrypted fashion, or just send it directly, when the January 6th committee filed their brief, which had attachments on it, the emails from John Eastman turning over those emails, the Dropbox link was still active, and so members of the media were able to access those emails. And so we actually did a video where we showed you what those emails were, and those emails were incredibly damning. And those emails showed John Eastman and other Trump lawyers basically saying that they know the lawsuits that they are filing are frivolous, but nonetheless they are filing them to try to delay the process while their friends Republicans in Congress would object to the results of the free and fair election. So it was all about delay, delay, delay. Some of the other emails talked about how they were trying to create some issue where the case would go before Clarence Thomas, hoping Judge Clarence Thomas would do them a favor, even though they knew there was no merit to any of their legal claims. And other emails showed that Donald Trump had signed false verifications under penalty of perjury in Georgia, attesting to stats regarding people who Donald Trump claimed unlawfully voted, which Donald Trump and all of Trump's lawyers knew that the information that Trump was submitting to federal courts and to a state court was absolutely false. So we got to see and read all of that stuff, which was in the 8 emails. So then John Eastman went to the Ninth Circuit Court of Appeals and whined and said, look what everyone's doing to me now. Because I waited until the very last minute, because I turned over the records to the January 6th committee myself. I didn't address this issue the day after Judge David Carter, the federal court, made his order. Not the day after that or the day after that. I literally waited, until the last minute. And then I created this whole situation because I was not diligent. That now I've been wronged because I had, and my lawyers had, a public Dropbox link that the public could access these records. So now, Court of Appeals, please order that the January 6th committee destroy these records. Please vacate, basically overrule the district court's ruling. We need you, Ninth Circuit, to make a finding now that actually the crime fraud exception did apply, and that now I, John Eastman, have been prejudiced by all of these things that happen, which I directly caused. And finally, the Ninth Circuit Court of Appeals, in basically a 1-page or page-and-a-half ruling, said absolutely not. We're not vacating Judge Carter's ruling. And the Ninth Circuit Court of Appeals said, all of that law you cited may be good if this wasn't all your fault. And let me pull up the document right now so you can see it. It's before a 3-judge circuit judge panel of McCowan, Wardlaw, and Fletcher. And then it says, appellant's request to withdraw the emergency request for injunctive relief is granted. Emergency motions are deemed withdrawn. And this is where it talks about vacating Judge David Carter, the federal court's ruling. It goes, appellants, that's John Eastman, appellants request that we vacate or remand with instruction to vacate the underlying judgment is denied. Then it cites a bunch of cases like United States versus Mussingir, Inc., but it stands for the proposition that the Munsingware rule is inapplicable when mootness results from circumstances attributable in part to appellant's actions. And so basically what the court is saying here is where the appellant, in this case John Eastman, is the cause of the mootness that he is now complaining about to try to withdraw the judgment by the district court. Here, the judgment was that the crime fraud exception applied, and John Eastman wanted to moot that, to vacate that finding on the basis that the January 6th committee has now accessed it and the information was revealed to be public. But here the Ninth Circuit is saying, no way here at all. You, sir, John Eastman, appellant, is to blame, so you can't cite the mootness to vacate the judgment by the federal court finding the crime fraud exception applies, where you, sir, John Eastman, were the cause of the issue you are complaining about. Namely, your lawyers put the link, you used Dropbox, a public link, and you didn't deactivate the link after the January 6th committee got the records. Also, you waited until the very last minute to even deal with and address all of these issues. Now, the Ninth Circuit Court of Appeals didn't say all of that. They just said the part that I read, which is that the rule about mootness is inapplicable when mootness results from circumstances attributable in part to appellant's actions. Here, John Eastman caused it, but that's what is meant by that statement. You caused all of this on yourself. And as I point out, this is the tactic used by MAGA extremists in our court. They don't actually litigate competently. They almost litigate with these games and to lose. So when they lose, which they know they would anyway on the merits, they try to whine and complain that they are being wronged. Look, case in point, you go to the Letitia James, the New York Attorney General lawsuit in New York, where she sought a preliminary injunction in connection with this fraud lawsuit for the Trump organization's purported and pretty much obvious false valuations and fraudulent valuations of their properties, where an appraiser would come in and say, your properties are worth X. And then the Trump organization, on their statement of financial conditions utilized by third parties, like lenders, they would say it's 10X or 20X or 50 times what the underlying appraisal value is there. And in connection with the New York Attorney General's preliminary injunction hearing to appoint an independent monitor within the Trump organization, the New York Attorney General set forth to prove their burden of a probability of success on the merits and that the equities are in their favor. That's what they need to prove. They submit affidavits which have detailed facts supporting the findings that Donald Trump engaged in fraud. Now, to rebut those findings in the court of law, a litigant is supposed to submit evidence. You're supposed to submit your own affidavits to rebut it, to show, hey, look, Tish James is saying that we engaged in fraudulent valuations, but here, through expert testimony, through an affidavit from Trump or Trump Jr. or someone at the organization, a controller, here's why Tish James is mistaken. The same thing that Donald Trump whines about in the horrific language he uses on his social media platform and during those fascist rallies that he holds. But Donald Trump offered not an iota of evidence, and that's what the judge said in New York. You haven't even submitted any affidavits to rebut what the New York Attorney General's saying. So I'm presented with all this evidence here, and then just your ranting and ravings and all of these assertions that you're making, these blanket assertions, without any evidence whatsoever to support at all what you're saying. And when you were questioned under oath, where you could have stood up for yourself and the valuations that you made, you pled the fifth over and over and over again, over 400 times. You pled the fifth, which in a civil case, a judge can reach an adverse inference, which is definitely the case here that's needed, where you also don't provide any evidence in response and in opposition to the preliminary injunction request by the New York Attorney General. So there's different cases and different forums there, but it's the same concept, which is the Trump and the MAGA extremists, they're not actually submitting any evidence at all. They're playing games, and then they whine about it when every day in courthouses across this country, there are cases where people are doing this the right way, submitting things diligently, doing the work the way it's supposed to be done. This isn't supposed to be as chaotic as they're making it seem. And when you go back to John Eastman, if he had an issue with the underlying order that the crime fraud exception applied, which was found on October 19th, well, then on October 20th, do something, or the 21st, or the 22nd, or the 23rd, 24th. Now, Eastman is a former law professor. He was known as being one of the, in his own way, before all of the Trump MAGA stuff, someone who is viewed as like constitutional scholar. It's shocking and devastating that someone with those bona fides then used it to try to overthrow our government and continues to do so today. But here's someone who was a law professor, who who fashions himself as this, lawyer who knows what he's doing, but then why not file the motion the next day or the day after that? It's because they're playing games here, and their intent is not to actually win in the court system. It is to use our court system for their fascistic ends. That's why we break it down here for you, all of the moves that they are doing, the outcomes, and what is really going on here. I'm Ben Meiselas from the MeidasTouch Network. Please hit the subscribe button right now. We just passed 700,000 subscribers. This is growing, and growing quickly. We're almost at 1 million subs. It's free to subscribe, so hit the subscribe button right there. Also, if you want to become a patron of what we do, check out patreon.com/MeidasTouch, patreon.com/MeidasTouch. There's lots of exclusive content there in the different memberships you could join, exclusive podcasts, exclusive behind-the-scenes posts, exclusive merch drops. Some of the tiers allow you to become honorary producers of the MeidasTouch podcast, and your name actually will appear at the end of the podcast, and you'll receive posters and postcards and so much more. But we are not funded by any outside investors at all, so we rely 100% on you and your generosity. So if you can help out, and wherever you are in the world, I always get asked, what can you do to help? That would go a long way. No pressure, but if you can, I know there are a lot of other subscriptions out there. If you can subscribe on Patreon, that helps this grow and allows us to stay 100% independent the way we want to be. I'm Ben Meiselas from the MeidasTouch Network. Until next time.
MeidasTouch is unapologetically pro-democracy. And look, we know you are too. So please make sure you check out our best-selling shirt and our best-selling gear, the unapologetically pro-democracy gear. And hey, while you're at it, make sure you check out my favorite shirt and one of our most famous designs, It Wasn't Rigged, You're Just a Loser, at store.meidastouch.com. That's store.meidastouch.com.